Express consent, that is informed consent, it can be of two types. Generally the written verbal consent and the written consent is giving the patient a consent form and simply asking him or her without further consideration on interaction with the patient is neither an acceptable practice nor fulfill the steps necessary to obtain a valid consent. That I was saying that we cannot give a person a paper to sign and that the consent has been taken. Again, I am emphasizing on that the consent should be the right of the patient, and patient has the right to know everything about the procedure, understand everything about the procedure, and with his rational mind he should take the proper decision in his favor, in his or her favor, not in the favor of the hospital or the physician. A patient is entitled to receive sufficient information in a way that he or she can understand in the same language. Again I am emphasizing on the language, because we mostly deal in the English, and in the society generally we have change of language on an average 5 to 6 kilometers. If we travel a distance of 5 to 6 kilometers, means some of the dialects of the language change in India. So we should be very much aware of the society in which we are practicing, and even that society may be having 2 or 3 dialects of the language. So we should be well versed with these languages and understand the person and make the people make our explanation to them in the same language in which they understand. We try to explain the language in English and the patient is not understanding English, and we think that we have explained. Patient said he is not informed. So this should be avoided at the very first point, that we have to understand the patient and the language and the society. Very means three things: patient, language, culture. These are the things we have to understand. If we are not able to understand the things, we are not a good practitioner, and we can somehow in some day land up in trouble because of not understanding the proper nature or the complaint of the patient because of the language. So another, which is the first form of the informed consent, is the verbal consent. We generally don't have time for small procedures to take full form of the consent and go all through. So we get the verbal consent from the patient in the presence of a disinterested party. Verbal consent is a type of informed consent in which the patient is informed about the procedure along with its risks and benefit. It is legally effective as written consent if taken in the presence of disinterested person, any of the supporting staff of the hospital, or any of the person who is with the patient. Sometimes there is attendant with the patient, that person is a disinterested person. Sometimes ward boys are there, sometimes whoever who is not directly involved with the, especially the money or any of the fees or anything, or is not involved with the any party, can act as a disinterested person. It is generally applied above the implied consent, including the examination of the intimate part and some of the minor procedure, but it is always better to have a written informed consent in presence of a witness or proving any case in the court if necessary arises. So it is most of the time written consent is better in all forms, because it is written, documented and being attested by both the parties. So it is very easy to reproduce in the court. More verbal consent is sometimes not able to prove in the court that this thing we have explained. Sometimes the witness may become hostile. Various things can happen, but in the written form, when the things are being documented, that cannot be changed in due process of time, and the court accept that. Written consent. Written consent is the consent of the patient for procedure after obtaining the information regarding the correct procedure and treatment in totality. It is often wrongly equated with patient signature on consent form. We should not be just taking the signature and go for the procedure. We have to explain. The signature on a form of is evidence that the patient has given the consent, but it is not proof of valid consent. Again, I am saying that if we have not explained it, then that consent form can end up in trouble. If a patient is rushed for signing a form on the basis of too little information, the consent may not be valid despite the signature. Patient may wish to withdraw their consent, although they might have signed a consent form. Either I was telling earlier that there is no continuous consent. There is no absolute consent, but it is a continuous process. In such cases, documentation in patient medical record is important. If somebody is withdrawing the consent, then we should document it into the medical records, because once the case has closed, patient is gone, complaint is lodged, the only thing that remains as the proof is what is being written in the case sheet. We don't mention everything in the, we have to complete the complete patient medical record incomplete, so that we should be get protected, because patient may sue and that file may be called in the court or to the board, and in that if there is a documentation failure, then it will not be considered on the mercy plea that we were busy and we were not able to do that, because once you have left and the time has gone, that will be considered as a negligence and we should be treated according to that. So, better more vigilant at the time of attending patient than feeling sorry later, which I teach my all students that we should be completing our medical records simultaneously without any excuse, because excuses will always be there, patient load will always increase, but at the same time we have to protect us also. So, we should be give more time to this in anyhow whatever it requires. We have to be very vigilant on this. Documentation of patient's record is mandatory, and then it is the only document that proves that what you have done and what you have not done. Requirement of a valid consent. Again, competence and capacity, which I was discussing earlier. To demonstrate competence and capacity, individual should be able to understand the simple language, what the medical treatment is, understand the purpose of treatment, the nature of treatment and why it is being proposed, its principal benefit and risk, and if there is any alternative treatment. So, we should always give alternative treatment or give a patient a better choice if it is available. If most of the time we don't refer to the patient to the specialist, that is also a mistake or on our own part. Patient may come to the court that he did not give me the alternative of expert opinion or another second opinion. Nowadays we are going that patient may want another expert opinion on the same disease or the procedure. So, we should give them that chance. If we are not going to give them that chance, then we will be landing someday or some way in future in trouble, and that trouble can be very, very harsh and can be very damaging also to us in terms of reputation, always, as well as in terms of money and the other forms. So, we should give the patient chance for everything. In broad terms, It is to understand what will be the consequences of not receiving the proposed treatment and retain the information for long enough to make an effective decision. So we should not invite trouble to ourselves. We should give person every information which is properly required for a particular procedure, and we should give the alternative also. If we are hiding something, if you are not giving something, so that may be a risk to ourselves. Legal age means the age at which the person can give the consent. In broader terms, I have not gone into the very much detail of everything of age. So we are just giving you major outline on this, that person of 18 years and above can give to extensive medical procedures and can go for even everything which is an adult can give the consent. But a patient between 12 to 18 years age can give to consent for physical examination and some of the minor procedures, but not any of the major thing which can be done. Minor procedures like sometimes drawing of the blood or something like that, but it is still not defined, very much clear defined here, but we should restrict ourselves. We should get an adult guardian to give the consent on behalf of that person. If a child is below 12 years of age, he cannot, or he or she cannot give consent for any of the treatment. So in these cases, we will get very much different scenarios. One of the scenario is no guardian. One of the scenario is one guardian, that is too sufficient. One of this is both guardian separated, both guardian divorced, then the custody battle, who is having custody. Then if the custody person who is having custody is not available, then who can give the consent? So various forms of child consents are there. We are not going into that, but as an expert or as a physician, we can come to all the situation like that, and we have to read further material on that. If any further course can go on that, we can go for simply medical legal procedures. In that we can go get into detail on that, how the things happens and how we should proceed. Sufficient information, that I was already explaining, that patient should get sufficient information for the treatment. That can include diagnosis, whether the diagnosis is correct or not, what are the disease, options for investigation, there should be option for investigation, materials or significant risks involved, we should be communicating to that. Common or serious side effects, that is another aspect. Outcome including benefit and limitation of the treatment, means if we are going for a certain procedure, then what are the results that can be there, and limitations, that a person will be morbid enough, person will not be able to walk, and person will not be able to do some work. We should explain prior to that. And one of the most promising thing is alternative to the procedure. We don't understand, we should give the person the alternatives, various alternatives. Patient may be, there are chance that we go for amputation or something like that, and person may not, if we have any alternative method, we should give that. Person may not be willing to get amputated, and various willing to go there and may be having another procedure to take. So we should give all the consequences of having a procedure done or procedure not done, and alternative to that. Consequences of not having a procedure and the procedure will be, we should also somehow tell the patient if the procedure is not going to take place, what may be the consequences but we should not be very much emphasizing on that that he should take the procedure from us only. Procedure will be carried out by which doctor, team of doctors, the junior doctor or the senior doctor, whether the senior doctor will be present or not, or only in the name of the senior doctor. This all should be given to the patient, because the patient may sometimes say that he was admitted under somebody else and was operated or done by the junior fellows. So patient may sue the unit. So he should be properly explained whether that doctor under he is admitted is going to be present during the procedure or not, or he will be somewhere outside and his team will taking the course. All should be explained to the patient, because sometimes patients are very particular for a particular doctor, particular physician, and we should not dilute his belief or his trust and something like that. The proposed procedure, the procedure may include: patient should receive a description of what the procedure is likely to involve, including expected length of stay in the hospital, how much days he will going to stay, how much medications he have to go through, surgery including site, size of any incision and likely scar, especially on the face or on the exposed part of the body. Nowadays we have very much signboards are going on that we have minimal invasive procedures and minimal on that. So we should be also mentioning how much minimal is that, and we should also clearly explaining how much that will have in the cosmetic effect. So we are in the era that patient doesn't want his bodies to be disfigured, so or he should not look awkward. So if we are promising something minimal, it should be minimal. If we are promising, we are taking careless attitude toward the suturing on the face, it may develop into a scar like that. The patient whole facial features may appear differently. So we may land up in trouble. So we should be, if we are offering particular specialized services, then we should be sticking to that, and we should be explaining everything to the patient, so that these are the specialized units which are being giving a specialized treatment, specialized themselves. So they should be more cautious in delivering the result, because more often and most important thing is how much accurate result we are giving to the patient. The need for intimate examination, that is another part we should be very much particular about during the procedure. How much pain the patient will suffer, approximate period of recovery, how much time the patient will take to recover, likely impact on the daily and personal life, that is another thing. How much mobility will be there, how much work suffering will be there for the patient, and especially personal life, that includes work, driving capability, lifting the goods, lifting the some of the materials, and also the sexual performance, sexual activity, that can be hampered or not. We should always be telling everything, so that person can take a informed decision. Tissue or organ removal, if we are doing tissue examination, sometimes we should also tell that this tissue will be examined. This tissue, if we are going to preserve for the teaching purpose, we all should explain that. And again, if we are going for recording of the procedure, we should also take the consent for that, especially for those who are going through the procedure during the conferences and all that, we should be or taking all the consent of the broadcasting and all that. Voluntary understanding decision authorization means a person has gone all our and explanations, all our procedures and that, and then the person gives understand that and gives the voluntary agreement, gives the voluntary consent. It should not be under fear of injury or under misconception. Any person doing the act has a reason to believe that the consent was given by the consequence of such an fear or misconception. We should not be over fear the patient, over emphasize the burden, or we should not be coercing with the patient to give the consent. The patient client must agree for their own free will to a clinical treatment or investigation and must not have any being subjected to the will of the third party, that is a relative, such as to vitiate their consent. So one should not be any involvement in the consent coercion. This voluntarily should come after full disclosure, risk, benefit, and understanding of treatment and procedure. Patient should also be made aware that this ongoing consent voluntary can be withheld anytime, any point of time during treatment or procedure. We should be giving every right to the patient so that patient should be very much conscious about it. Again, the refusal of the consent after taking all the informations, all that the patient you have given to the patient may refuse also. That is not a part. That is not a problem because it is the part of the part of the procedure. Patient may take take our advice and go under the treatment. A patient may not. Can take our advice but may not undergo under our treatment. Then he has proper right to refuse the consent. Competent adults are entitled to refuse to treatment. When this situation occurs, it is important to consult and discuss with all those who are concerned about the patient. Alternative to the proposed treatment procedure should be discussed with the patient. Advice should be sought from senior colleague. Certain situation it may be necessary to apply for court order in order to render treatment for a patient. Sometimes if the patient doesn't agree and the procedure which we are proposed that if not taken the patient may die and he is adamant not to take the treatment, then we can inform to the magistrate about the situation. If magistrates understand that the life of the person is more important than his will, then the magistrate will take the person and give the person consent on his or her behalf. So we should not be very much in our own control. We should involve the authorities, especially the local authorities or the court or the magistrates, so that we should be protected and they should act on the behalf of the state and on the behalf of the patient. When seeking assistance of the court in such matter, it is important to keep the patient informed as a concern with them throughout the procedure. Patient should be informed that we have informed the court, and court will come, magistrate and the other will come and take their own evaluation and do their own evaluation and will do whatever is properly required. All discussion and actions taken should be documented. Again, I am emphasizing on the documentation. All the things should be documented and should be kept in the health records. Exception to the rule of obtaining consent. Again, we have certain privileges also that are acknowledged, that there are two different common law rules, that therapeutic privilege and emergency life threatening situation. That I have already in the initial lecture I said that we have certain advantages also in emergency or therapeutic privilege, that we will be discussing about it. Therapeutic privilege means A clinician can withhold information if he or she feels that it would be psychologically damaging to disclose. So sometimes a patient is having heart condition and very severe of that, and we should be mild on explaining on that, and that if we fear that that person may have a certain psychological damage on the patient, or the patient is having may land up further in that, so we can withhold some information for the benefit of the patient. But this privilege should be very rarely exercised. We should not be exercising it regularly, because nowadays, whether it is in the we think it is for the better of the patient, nowadays the information exchange system and the people of curiosity of people knowing everything should be more respected, because if we are not respecting them, then they go against us in some way and ask in different manners that will not be very pleasant to us, for us. Though the information should be withheld in a therapeutic privilege if anyhow communicated in good interest of the patient and result in any misadvantage is not punishable by law. So which we are protected here also by in IPC 93, that if we have withhold some information for the best interest of the patient and person has died or some happening has happened, then we are being protected there. Life threatening situation, that is protected by IPC 92. In that, in a life threatening situation or in emergency where the patient is unable to give consent or appreciate what is required, the clinician may administer the necessary medication treatment in the presence of an express consent of the in presence or absence of the express consent of the patient, because life threatening situation is there, patient is not conscious and no attendant is there, no relative is there, then we may give emergency treatment for the saving life of the patient. But when the life is saved, then we can inform the patient that this has happened, we have taken this, and we should inform our hospital authorities too, or we may involve our hospital authorities first, and they can give consent on behalf of that on the concept of loco parentis. Means loco parentis is a concept where the nearest available guardians can give the consent. Sometimes nearest available guardian is warden, even sometimes nearest available guardian is the principal of the school. Sometimes the nearest available guardian can be the medical officer, chief medical officer, and all that. We have different remedies for that, but we should go according to the hospital protocol or the protocol of the state, which dictates in case of emergency. We should read all the laws for our benefit. This is also known as doctrine of necessity. Means it is if we do not do the necessary things, the patient may die. This is mainly applied to the destitutes who have no one with them, unconscious patient, intoxicated and disoriented person. So in most of the cases, these are people who are either have no one with them, or unconscious with them, or intoxicated. In any way, their mental capacity is somehow deranged or unconscious. So we should be having life-threatening procedures. Indian law provides to treat such patient without consent, provided the act should be in good faith or the benefit of the patient. This doctrine also applies to the emergency situation in case of child who is presented to the hospital unattended. Means some guardian should be there. If not, if emergency is there, we can proceed with in good faith. With this, we have come to the very small but very understanding topic of consent, and we should be reading more about it, and we should be more conscious about it, and consent should be, as I am emphasizing, I have told that in the clinical in the injury report how the consent is to be taken. Same thing happens here. We have to explain everything, we have to document everything, how we have explained the consent, and then we have to, consent should be written, or then we have the patient or the attendant or who has given the consent should either sign it or left thumb impression, right thumb impression. We should write the name in capital letter, then we should sign it and should verify it. So all the same procedure for the consent, and we should also know the theory and the various laws behind that. With this, we have come to the end of this lecture. There may be some additional topic we will be covering in 1 or 2 days. Though we have covered all our lectures, including the injury report making and all that. So we should be maybe additionally adding some of the topics so that people may understand some of the things which are also needed in the or somehow related to the injury or making of the injury reports or the somehow evaluating the injury. So we can add further lectures to make more understandable and more explanatory. Thanks with that, and we will be in touch in the coming lectures. Thank you very much.